We're all told that if you're in trouble, you have the right to an attorney. It's like a fundamental part of the justice system, right? But what happens when that right kind of falls apart? What if the very person who's supposed to be fighting for you makes a mistake, a huge mistake, like missing a critical deadline, and it costs you your shot at justice? Well, that's exactly what we're diving into today. This is a story about what happens when the system fails and one person's fight to get a second chance.
So, here we have it. This is the official word from attorney Adrian Smith, sent directly to the Oregon State Bar. His client, a woman named Ashley Higgins, had filed a complaint, and this is his response. In black and white, he says her right to appeal has been preserved. It sounds confident, totally definitive. Case closed, right?
Yeah, about that. He made his position crystal clear. But as we're about to see, the actual evidence tells a very, very different story. That one little question, was her appeal really safe, is what blows this whole thing wide open. And this, right here, is where it all starts to unravel. This is an email from that very same attorney, dated August 4th. And in it, he tells the bar that he has just started the appeal process for Miss Higgins. So why is that date, August 4th, such a big deal?
Well, let's just look at the timeline. The clock started ticking on her appeal the day she was sentenced, back on May 29th. Under Oregon law, you get 30 days. That means the deadline was June 28th. So his email, saying he's just starting the process, came more than a month after the deadline had already passed. Her right to appeal wasn't preserved. It was gone. And that one fact is the explosive center of this whole story.
So, to really understand how things got so messy, we need to rewind. Let's go all the way back to the incident that pulled Ashley Higgins into the legal system to begin with.
It all kicked off on September 5th, 2024. There was a big confrontation, and at the very heart of one of the most serious charges, unlawful use of a weapon, was this dog.
As you might expect, the police report tells two completely different stories. The victim said Ashley Higgins attacked her and ordered her dog to get her and kill her. But Higgins and her co-defendant, they said, no way, the other person was the aggressor, and they were just defending themselves. A classic he said, she said situation.
Based on all this, the state didn't hold back. They filed some really serious charges against Higgins, including 3 major felonies. I mean, the stakes for her could not have been higher.
But this case wasn't just about what happened that day. Pretty soon, it became about the relationship, or maybe the total lack of a relationship, between Higgins and her court-appointed lawyer.
Okay, so you can see from the documents, for months, Higgins was desperately trying to get in contact with her attorney. Here's an email from January 6th where she says she's getting increasingly anxious because she's hearing nothing but silence.
And then, literally the very next day, another one. This time it's even more frantic. She says, I have urgent matters. She was trying to figure out how to modify a no-contact order because it was affecting her kids. And this pattern of just being ignored, well, it would become a massive piece of her legal argument later on.
So what was his excuse? When the bar asked him about it, his official response was basically, hey, I'm a busy guy. He talked about court appearances, prepping for trials, personal obligations. He even said his clients could just call his investigator's office if he was unavailable.
Now, this total lack of communication is the backdrop for 2 absolutely critical legal moments that happened almost at the exact same time.
So get this, while she's getting advice from this same lawyer, Higgins is dealing with 2 different cases. On April 24th, she pleads guilty to a charge of hindering prosecution. Then, just 2 weeks later, she's in court, going to trial on those much, much more serious felony assault charges.
And the result from that trial was, wow, just stunning. The jury found her not guilty of attempted assault, not guilty of assault in the 3rd degree, and not guilty of menacing. They acquitted her of the 3 biggest charges she was facing. She was only convicted on the lesser charges. This was a huge, huge victory.
Which brings us to this really powerful question. Let's just put you in her shoes for a second. If a jury listens to all the evidence and decides you are not guilty of the absolute worst things you're accused of, wouldn't you start to seriously question the advice that led you to plead guilty in a different case just a few weeks earlier?
And that exact question, combined with the whole disaster of the missed appeal deadline, well, that was the breaking point. It pushed Ashley Higgins to do something pretty dramatic.
She decided she was going to fight back, and she was going to do it herself. In the legal world, there's a term for this. It's called acting pro se.
So in a motion that she actually wrote and filed all on her own, Higgins argued that her guilty plea in that other case should be thrown out. And her reason? Because it was the direct result of constitutionally ineffective assistance of counsel. She was calling out her lawyer, on the record.
And her argument was really clever. She basically said, look, the fact that my lawyer completely failed to file my appeal isn't just a separate screw-up. No, it's the ultimate proof. It's the smoking gun that he was giving me terrible, negligent advice at the exact same time I was relying on him to decide whether to plead guilty.
And what her motion does is it brings this whole story right to the doorstep of a critical legal idea. The right not just to have a lawyer, but to have an effective one.
Now, to win a claim like this, she has to meet a really high legal standard. It's called the Strickland test. First, she has to prove her lawyer's performance was deficient, that it just wasn't reasonable. And second, she has to show that this failure actually hurt her case. In other words, there's a real chance the outcome would have been different if her lawyer had actually been doing his job.
A claim like this, as you can imagine, kicks off a whole serious formal process. For the attorney, it means he has to report it to his insurance and build a defense. For Higgins, it means she's starting down a long road that could end in mediation or even a formal hearing. This is how the system is supposed to provide accountability.
And this entire case really just forces us to ask a tough question about our justice system. The Sixth Amendment says you have the right to an attorney. It guarantees it. But what is that guarantee really worth if the lawyer you get is inattentive, unresponsive, and ultimately ineffective? What happens when a right that looks so good on paper becomes nothing more than an empty promise in real life?